a professional fiduciary involved in settling an estate and not. We have someone who has great experience in that area to talk today. Michael Henkenius has been a member of this group for almost 30 years, has worked, has every certification you could probably have for this kind of thing. He's a certified advisor, a trust advisor, chartered advisor in philanthropy. He's been worked in for the Catholic Diocese of Lincoln as a plan giving officer, as the executive director, has been a philanthropy consultant for Steyer Group, and now has been for 8 or 9 years at Union Bank as a trust officer. So it's great to see both sides of the thing. People are paying out the money to organizations, and he's also been on the side trying to bring the money in. And so we're going to have a chance to hear from him about his thoughts on what happens when you find out you're in the state. What else can I say? We were talking today how Michael doesn't have much time. He has basically a basketball team full of children. He's got full size plus
True.
Coaches, and probably has already golfed more this year than I will all season. And this is always active. I mean, volunteering a lot, always part of the community, and really probably doesn't sit around very much. But I'm really interested to hear what you have to say about settling estates. And welcome, Michael Henkenius.
Yeah, thank you, Keith. Welcome, everybody. So yeah, I have been, when I first started in 1997 as a plan giving officer for the Diocese of Lincoln, I joined at that time, it was called the Plan Giving Council of Nebraska. And so it's really a pleasure to be able to visit with all of you. So I've been a member since 97, and it really was instrumental in my career. When I first started, I didn't know anything about plan giving. So I don't know if there's any guests here. If you're not a member, I really encourage you. And it's great that you're here because it's such a unique organization that is collaborative. Even though in one sense, you're all competitors, kind of in that way, but it was just really important for me at the beginning of my career to have this group, now the Charitable Gift Planners in Nebraska. So, but this is my 30-year law school reunion, and I saw something funny on Facebook, because I'm old and I'm on Facebook, and it said somebody was talking about things that were happening 30 years ago, and in my mind they were talking about the 70s, but they were talking about the 90s, and now I have to go lay down. So that was kind of good. So I thought we'd take a little time capsule back to 1997, just a little snippet, what was going on 30 years ago. So Bill Clinton was president in 97. The Dow was at 6,442 in 1997. It's now at about 42,000, I think. The federal estate tax exemption was 600,000. Okay, if you had more than 600,000, you had to pay federal estate taxes. Google was 1 year old. You just were starting to Google things. Microsoft Outlook. I remember I had my computer and email, and Outlook 97 was amazing. What else was happening? The #1 song in the country on January 1st was Unbreak My Heart by Toni Braxton. Anybody remember that one? She was amazing R&B singer. The #1 selling album in 97 was Spice by the Spice Girls. You remember the Spice Girls? They sold 10 million albums in 1997. That blows me away. The Green Bay Packers won the Super Bowl. The Florida Marlins won the World Series. So, and what can anybody name the last important event in 97? That's right. In the state of Nebraska, last time Nebraska was national champion. So thanks for joining me on a trip back to when I started in the plan giving world. So just to kind of get things started on kind of what we want to do, of course, disclaimer, we're not, I'm not going to give you any legal advice. I have a law degree, but I've never practiced. So the goal of this isn't really to dive into the minutia of the probate process. what we want to have is, and I love the way that we started off with the discussion. And so I do want this to be a discussion on experiences and best practices on, again, bequest administration and tracking. And so really the focus of what I'm going to comment on is you're in the will, your donor has passed away, okay? So you know you're going to get a gift from their estate. That's kind of a focus, but we're going to maybe delve off a little bit on talking about expectancies and also talking about, maybe discovering that. But that's kind of going to be the focus. And obviously, I'm a trust officer, and so that's kind of the viewpoint that I'm coming from. Maybe kind of the ability to pull back the curtain a little bit, maybe on some tips, for charities on, hey, what can we do maybe to be a little proactive? We know Joe Donor's passed away. We know that we're in his estate. Now, what do we do? Okay, so that's kind of going to be, but I do want also, I would like to kind of have a little give and take and maybe get some polling on some of the ways that you're also doing some things. So, and then obviously feel free to, we'll probably have time. I probably will not go the whole time here, but okay, so really, so you found out that your donor has died, okay? And the various ways, obviously, maybe you are close enough in your relationship, you actually got a call from the family, okay? Or maybe you received the news secondhand. Maybe a staff member came in and say, hey, Michael, did you just find out, I just found out that Joe Schmo has died. Or how many of you read the obituaries? Everybody? Okay, yeah. Maybe oh my gosh, that's our donor, died today. So I'm just kind of curious, for the last time that you had a donor pass away and you were in their will or trust, how many people received a call from the family? They said, hey, Michael, I just want to let you know that Dad died. Nope. Yep. Okay, that's amazing. That's great. If the family's calling you to let you know, that means you've had a wonderful relationship. How many of you secondhand you learned that you're in their will or trust? And how many of you just read it in the obituary? You found out. Yeah. Okay. So kind of all three, right? Those. If there's another way, raise your hand. I remember when I worked for the Diocese of Lincoln, we did read the obituaries, and we used that really even as a source of, if it's a good obituary, it's got an amazing amount of information. And we would update our database with, oh my gosh, I didn't know that this person was a cousin and aunt and uncle. And so I would encourage you to do that. If you're not, it's very labor intensive. You got to have the time to do it. But so obviously you're going to send correspondence, right? Here locally, I know we were talking with Arbor Day, and obviously they're a national organization, so you can't go to the funeral in Seattle, right? But those are the things you want to be doing, right? Sending. Does anybody's organization make memorial gifts? I don't think you would, but I'm wondering. Like, so University of Nebraska Foundation is named in the will, and the memorials are going to Lincoln Children's Zoo. Do you guys make memorial gifts? Okay. Right. That's a little more, yeah, that's a little more practical. But also, are you remembered as memorials, right? So maybe you're not in the will, maybe you're not in the trust, but memorials go to Nebraska Wesleyan, right? So be aware of that. And so I think it's important if you get those memorials, if I don't want to say if that's all, but if that's how you're remembered, to really be aware of that, stay on top of that, and write those letters, right? So obviously that's the first thing. And while obviously, you've had that relationship, especially if it's somebody's close to you, you've got that sympathy, and you've got that loss, but it's also, you're excited from an organization, and that all the work that you did over those years, you're going to now be able to carry out the wishes of your donor, right? So let's take a look at one scenario. And so this first one is, okay, you've had a donor for 20 years, or maybe you're new to the organization, but they've been with the organization for 20 years. you actually have record that they've remembered your charity in their will or their trust, right? So let's take a look at that. So you have a physical record that, hey, we are in their estate plan, okay? So if you've been notified by your donor, you have a record of it, kind of a copy of a legal document. You have a copy of the trust in your file. You have a copy of the will in your file. You're actually in the minority, right? I think, and maybe this is your experience, maybe not. Maybe you all know everybody who's named you in your will, but I did a little search on plangiving.com. This is from 2023. 30% of donors who make a bequest notify the charity. So I don't know if that's jives with what your research shows, but I do think our charitable organizations, most of your bequests or estate gifts you probably don't know about is going to be my assumption. So, but let's say you do, okay? So let's say you are, we're going to work under, kind of talk about a little bit. You have record of it. So go to your file, right? I would encourage you, and hopefully if you either have electronic file or you've got the old-fashioned hard copy, right, to get out that correspondence, get out that copy of Michael Henkenius's will, right? And so is it 5 years old? How old is that will? So you want to kind of go and do a little detective work. Most people write their final will sometimes in their 70s and 80s, okay? So if this is a will from 1985, we may not still be in the estate, okay? If this is a will from 2023, I think you're in pretty good shape, right? So just go to the file, review that, and kind of you want to go right to the date. How old is this? Then what I would recommend is, you're in there, just set a reminder to contact the attorney or family member like 2 or 3 weeks after the date of death. And just if you're wondering, well, how do we know who the attorney is? A little tip, especially if it's a recent will, just go to the notary page, and if a lot of times the attorneys will notarize, right, the will, and so you might recognize a name, or maybe your files are so good that you actually have that. You have a nice expectancy sheet. You've got the names of the attorneys. So I would say let the dust settle a little bit, because you want to make sure, again, if you're in this kind of gray area, the will's 15 years old, maybe we're not still in there, but we got a copy of a will. I've got the attorney's name. Follow up with the attorneys would be something that I would recommend, and just say, hey, this is Michael Henkenius. We've got an old copy. I see that Jane Doe passed away. We've got an old copy of a will. Can you tell us, are we still in there? So that, and obtain a recent copy. That's just something to maybe to solidify that. And then they, if you're not in it, they'll probably confirm that, and then you can kind of move on. But let's say they do confirm, yep, you're in there, you have the most recent copy. Just, it'd be good to provide that contact information to that attorney or to that family member, because a lot of times they might not have a reference point for the charitable organization. So it's good to just kind of take a look at that. And again, you may be dealing with the little gray area here, but if it's a fresh, something recent, more than likely you're still in the estate plan. So let's kind of take a look at a more common scenario, right? That you just have a very good relationship with your donor, but there's no expectations you're in the estate plan, right? You don't have any record. They're just a major gift, or maybe they're just a long-time giver. You might still try one little idea. So the personal representative is the person that's named as the person in a will. They're actually listed. They are the ones that are in charge of administering a person's will, right? So they will want, whether it's a person, whether it's attorney, whether it's a corporate personal representative, they will need to file a will to get going on their work, right? If there is a probate process, if there's a formal process where they're administering the terms of the will. So a personal representative can file a will 5 days after the date of death in the county court. Okay, and when I actually did this when I worked for the Diocese of Lincoln. If I had a hunch, now obviously you're not going to have time to do this for all of your donors, right? But let's say you have some old note that said, hey, they said they left us in the will, but you don't have a copy of anything. I would wait about a month or so, and I would go down to the county, Lancaster County Probate Court, and I would see, is there a will there? And sometimes, not often, but sometimes we would be in there in their estate plan. So that might be one thing where you might have a hint that you're in your donor's will, but you don't really have a good record of it. They actually, that you can go down and you can get a copy of the will down at the court. Now, obviously, you're not going to have time again to do that for everybody, but just kind of one little tip. And then more than likely, if there's some ambiguity and you are in the will, but you don't know, you're eventually going to get notice from the personal representative, because the personal representative has a duty to then notify the beneficiary. So that's probably the more common outcome of scenario B. But on the off chance, you go down to the county courthouse and you look and boom, you're in the will. That'd be an exciting day for you. Okay, so trusts, obviously a lot of our donors, and I would say a lot of our more high net worth donors, they have trust, right? The same principles really apply being named in a trust as far as reviewing your files, right? You'll have a copy of the trust. Again, the exact same the same scenarios work. It's just that it's a trust document rather than a will. Again, set your reminder to follow up with the attorney. Hopefully, if you have the attorney. The downside of a trust is, and this is a lot of reason why people do trust planning, is it's not public, right? And so if I have a trust, I don't file that at the county court. So if you're not in the trust, you don't have a right to the trust. There's really no way that you're ever going to find that out, like you can by going down and getting a copy of the will. But again, the same principles apply if a beneficiary in a trust and you've got that on file. Got to move this up a little bit here. There we go. Okay. One of the things, I'm going to pass this out. It's interesting, the state of Nebraska, and I'm going to go to a website here to show you guys. There's actually kind of some decent resources. The Nebraska Supreme Court has, I don't know if anybody's ever gone there, but it's got a lot of good legal resources for the public. And so this, I thought, might be interesting to share with everybody. This is just from the Nebraska Supreme Court. And I'm going to show you, I'll go to the website here and show you where you can find this. But this is just a flow chart. I'm a visual learner, and so I like, if you've never seen a flow chart of the probate process, now you have. It's a great day. But and again, we're not going to, but I'll kind of show you. I wonder if I can back out of here. Yeah.
Your last question just made me think about with Nebraska state inheritance tax.
Yes.
People who do trust still have to list who benefits from the estate because of the tax.
Right.
That would be for individuals. Do you know if charities are also listed then as beneficiaries in those calculations?
Yes, they are listed, but they're exempt. And we are gonna touch on that too, just a little bit.
Would you be able to find that out through the courts?
That's a good question. If you're a beneficiary, you're going to get notice way before the inheritance tax is prepared. The inheritance tax, and we'll touch on that, but so you'll know way in advance of that. Yeah. So I just thought it'd be interesting. So you can go to the, and it's on the bottom of your sheet here. Just go to Nebraska Supreme Court Legal Resources and Information. It does have a lot of information, and I, until recently, never really played around here. But this chart here is on that website, Nebraska Supreme Court. And if you scroll down here, if you go to estates, it has some decent information. Just it might be worth some time, some afternoons to kind of look and see. But this is where that chart is. If you wanted to share this with staff or just make photocopies, I just thought I'd point that out. But this just to know that this website is kind of an interesting for all kinds of, not just in estate planning, but just all kinds of good legal education. So just wanted to throw that out there. We'll get back into the slideshow. All right, so just to kind of walk through this, I hope it pops up. There we go. So again, at the beginning of the process, your personal representative, again, they're going to want to get to work, right? And so they have to file the will with the court. And this is a scenario where we've got a probate, okay? So we're going to assume the person doesn't have everything titled into a trust, okay? So it's a will situation, and there's actually enough assets to have a probate. So the personal representative is going to have to file an application with the court. More than likely, it's called informal probate, okay? They're going to get their letters of personal representation. They have to accept the appointment, right? And so they use that piece of paper. I've got my PR letters, and then they show that to the different financial institutions, and it shows I can act legally for the estate of Michael Henkenius. And that's how they collect the assets and do their business, right? They file an affidavit of mailing notice, and here's where, you're going to get notified if you're in the will, right? And so they have to, as the PR, they have to say, okay, Judge in Lancaster County Court, I've notified all the beneficiaries. The items in what color would that be? Mauve, pink, whatever. The darker color are optional. I don't think I've ever had a bond in an estate that we worked with. But the inventory, this is a great tool for you if you're in the estate, your organization is named, because they have to file, the personal representative has to file an inventory 3 months after they're appointed. And what that says is, it says, okay, court, here's everything Michael Henkenius owned at death. Here's the size of his estate. And that is something that you, as a beneficiary, if you're in the will, you can review that, right? And then you can glean lots of information, and you can even internally know, okay, this is what maybe we can expect. So that's an important date. And in your file, I would set a little reminder, 3 months after the PR is appointed, hey, we can expect an inventory. I can maybe ask the PR for the inventory, okay? So that's what I would do, is set a little tickler 3 months after you're notified that the personal representative has been appointed. Then they need to file that inventory. And here's where that inheritance tax comes into play. So this is due in Nebraska, our inheritance tax worksheet. That can be done anytime, but the deadline is 1 year from the date of death of a person, okay? And in Nebraska, we have inheritance tax. And every year the UNICAM wants to get rid of the inheritance tax. And every year they fail. And it's just kind of frustrating for some folks. But it's actually not a draconian tax. In Nebraska, our inheritance tax is paid by the beneficiaries. And practically, the personal representative will pay that from the estate before they distribute everything out, right? Because, why? Because the personal representative is on the hook for those, right? So they're not going to give everybody the money and then saying, oh boy, we forgot to pay inheritance tax. They're going to pay that first. But in Nebraska, they divide that up into 3 classes. Class 1, and these are classes of beneficiaries who have to pay tax. The first class is parents, kids, and siblings. They pay a 1% inheritance tax, okay? And they also get a $100,000 exemption, right? So if I had 3 kids, I have $300,000, there's no inheritance tax, right? Because each kid's got that exemption. So there is a nice sizable exemption in Nebraska for class 1. Class 2, if there's no parents, kids, and siblings, we go to class 2, aunts, uncles, and cousins. They get a $40,000 exemption. They're taxed at 11%. And then finally, class 3 with inheritance taxes, they get if it's just an acquaintance, non-relative, $25,000 exemption, and that's taxed at 15%. So it does get a little more hefty, but charities are exempt, right? So your charitable organization is exempt from having to pay any inheritance tax. You get the entire amount. And this is maybe a talking point if you're having discussions. Let's say you're talking with the donor and they are going on and on about how they hate Nebraska's inheritance tax. Really? Well, did you know that if you remembered us in your will, that will help your inheritance tax situation, right? Because it lowers the value of the estate. Maybe you can get it under the exemption amount for the rest of the family, or just knowing that everything that you're going to give to us is exempt. So just a nice little talking point for you. But that's just a little sidebar on inheritance taxes. And then the flow chart kind of just shows, you move your way to, you pay all the taxes, you're paying all your bills, and then most of the states would have informal closing, right? And they just basically are mailing statements to the court, and then they paid all the beneficiaries, and then they tell the court, all right, the estate's over. So that's just kind of a little flow chart for you if you're ever curious, how in the heck does the probate process work? I know you were. I know that kept everybody up last night. But so what if there's no probate, right? What if there's no probate? And this is kind of a lot. If you're going to have a sophisticated high net worth donor, more than likely they're going to want to avoid probate. Probate's not the end of the world in Nebraska. But a lot of your donors are probably going to have trusts and own things in trusts because they don't want to get into the probate process. So let's kind of switch gears here. Now we're going into trust administration. Quite often your donors are going to have a will still, but the will is going to be a pour-over will, and they're really going to say, everything I own pours into my trust, right? And their assets are going to be titled to their trust, their house is in the trust, their accounts, the beneficiaries. So if they've done a nice job, they've worked with professional advisors, they've titled their assets in their trust, there won't be a probate process, right? So you won't have, what does that mean? That means, you can't run down to the courthouse and get a copy of the will. There's no court supervision with the trust administration, right? I don't have to go and as the trustee, I don't have to file a trust with the Lancaster County. So there's none of that formal process. But it's not the Wild West, right? There's still laws that govern trust administration and guide trustees, right? So Nebraska has the Uniform Trust Code. It's our state law. We've adopted the Uniform Code, which means there's states across the country have kind of a similar structure for trust administration. And it's actually a lot of obligations on the trustee. There's lots of duties that are codified in our state. A duty of loyalty, a duty of prudence, right? They have to act like a prudent person. They have to be loyal to their beneficiaries if you're a trustee. You have to act in good faith. You have a duty to inform and report, right? You have to keep your beneficiaries informed of what's going on. You have a duty of impartiality. Now, you can't favor your favorite charities versus the kids, or if you didn't like the one cousin, but you have to keep everybody equal and you have to act impartially. You have a duty to administer the trust in accordance with its terms. Okay, so if you're a trustee, you can't just make things up. You have to follow, I have written there, the four corners of the document. All right, you have a duty to control property and keep records and accurate record keeping. So just because there's no court supervision, there is still a very high standard for being a trustee. Okay, and so you shouldn't have to be worried about, wow, there's a trust and everything. They're just gonna, and even if it's a person, and we're gonna kind of take a look at that.
How much time do you have to do that?
So in the probate, the Uniform Trust Code, requires you to give notice to each of the beneficiaries within, I think it's 120 days. And then what that does, they have to serve formal notice on the beneficiary, because then as a beneficiary, you have that kind of starts the clock on your ability to object to the trust, or maybe you have anything, and sometimes that'll happen in kind of litigated estates where, maybe there's a sibling fight or something, they would object to it. Yeah, Keith.
Anything continuing, one of the things to think about that qualified beneficiaries, you can request a copy of the trust of the financials. So
Right.
it's not first one dies, at least a lot, the trust created at the first death.
Right.
Might continue to the second, and I know what that says.
Yeah, that's a good point. So, take the example of the spouses. Maybe they've set, wife passes away, she sets up a trust for husband, and you're kind of a remainder, you're a qualified beneficiary. So at that point, you can request statements. You're going to have a gift after the husband passes away. So that's a great point. You're a qualified beneficiary. So you can kind of still maintain contact and get statements and get notice. Yeah.
Is there any obligation for the administrators to respond or return in any certain time frame if requesting information like that?
Right. There's nothing in the Uniform Trust Act that says within 2 weeks, but they do have a duty to inform and respond. So it has to be reasonable. I would say if your organization, let's say your donor names their kid as a trustee of their trust. Let's say you're named, they give you, and we're going to kind of dive into this a little bit, but you're named as a specific dollar amount. If they're not responding to you, they're breaching that duty. There's no set time period, but they do, under Nebraska law, have to respond in a prudent way to your requests. Right. And so if they're not, what's your recourse? That we're going to get into that here in a little bit. Right.
If they're out in a different state, then do they follow the beneficiaries' state laws?
No, it would be, yeah, hopefully they have the Uniform Trust Code. Let's say it's in Iowa, right? Let's say your donor lives in Iowa and it's Carroll Savings and Trust in Carroll, Iowa. That's where I grew up. They still have those general duties. I forget how many, do you know, Keith, how many states have adopted the Uniform Trust Code?
It didn't apply to information I was trying to get, and the previous one basically made the trustees do nothing.
Really?
And had my trust, they're not what I wanted.
Okay.
Trust put into existence, 6 months later, they would have had to follow all the duties.
Oh, wow.
We're going to do something, but not everything, because you don't have to.
Yeah. And we're going to touch on that here in a little bit. But yeah, I mean, if you have, we've got lots of wonderful corporate fiduciaries in our state, right? They're going to do a good job of responding to you, and attorneys. And we're going to touch on that here in a little bit. But good question. So unfortunately, it doesn't say if a beneficiary has a request, you must respond in 2 weeks, you must respond in 3 weeks. Hopefully they do respond. So it's important to know, okay, who are our actors? Again, the main actor in a will is their personal representative. The main actor in a trust is your trustee. And so a lot of times people will name individuals as their personal representative or their trustee, okay? So if Uncle Leo is your PR and you know that, you've got a copy of the will and you see Uncle Leo's the PR, you might be in for a little more rocky ride if, obviously because he's got other things to do other than to be trustee or be the PR. It's going to be less formal. They're probably going to be slower, Victor, to respond to your phone calls, right? Because he's working during the day. You might have not as good information if it's an individual. So it's not the end of the world, but just kind of maybe lower your expectations a little bit with that. And then if we get to attorney or corporate trustees, obviously more formal, you'll hopefully have more accurate information. Particularly, are there any practicing attorneys? It's going to be slower if it's an attorney. I guarantee you it's going to be slower. I wish I could live in the world and be an attorney where I didn't have to respond to emails and phone calls and everything else. But so, I mean, honestly, it will be slower probably just because that's just kind of their world. And hopefully with a corporate fiduciary, it will be a little bit better service for you. And you'll have that standardized reporting. You'll have a little more better information. They've got accounting software. They have nice statements. So it's just important for you to know, okay, who are the actors here? Because if Uncle Leo's in charge, I might want to stay on top of this a little more than if, you know, Pinnacle Bank's in charge, right? If they're their trustee, I'm a lot happier as a charity just because I know this is their job, right? They're gonna be able to return my calls. Yeah. Yeah.
I've noticed more of the attorneys I'm working with are encouraging corporate trustees for estates, especially as a backup for that. But before, it was kind of everybody wanted some individual to do it. I'm hearing that more and more, which I'm sure you're glad to hear.
I'm thrilled to hear that. Yeah, are people seeing in like with your last gift, was it a corporate fiduciary or was it an individual? How many people had worked with a corporate trust officer recently? Yeah. It's a bit, are people seeing that a little more, or are you seeing kind of still a mix? Mix? Yeah. I think there's a lot of times there's sensitivity to cost, right? We don't want to pay doctors, we don't want to pay attorneys, and we certainly don't want to pay a corporate fiduciary to settle dad's estate, all right? But we'll go in and we'll spend $500 on a new set of tires. So, but so a lot of times if your donor's sensitive to that, they'll probably name a relative or children, right? My son can handle that, or my daughter's going to be, yeah, Keith.
Perfect situation right now where it's a problem. Two really competent PRs, somehow in the East Coast,
Okay.
have passed away. And the fill-in was basically drinking buddy from next door who doesn't understand really complicated estate, but you know, this guy was on his last legs and needed someone.
Okay.
But more maybe you can help you think about is generally when people are setting up estates and thinking about fiduciaries, there's an estate size. And so someone with a $200,000 estate, and most trust companies, it's not going to be a client that they're going to take on. And so that's where I see that breakdown for estates less than $1 million, especially less than 500,000. Finding a corporate fiduciary in some parts of the world that will take that on seems to be a challenge for people.
I would 100% agree, right? Because obviously a corporate fiduciary it's not a charity, right? They're a business. So we're trying to make money. So we do have minimums. So that's exactly right. If you have a donor and maybe they're going to come to you for advice and they might say, you know, Keith, who should we name? If you know, look, they've got $100,000, they don't really need a corporate fiduciary per se. If they have a $10 million estate, they should have a corporate fiduciary or at least have an attorney or professional advisor capacity to serve as trustee. But that's exactly right. So it would be hard to find a corporate fiduciary that would take an estate below 250, 500. Every different trust department has its different minimums. But yeah, that's exactly right. And hopefully it's not the drinking buddy.
We can influence that, I think, helpful for those that do have that kind of wealth. Just, you know, I think they're many of them have gotten that kind of wealth because they've saved all the pennies. But I think, you know, the burden of being a trustee for somebody who's never served as a trustee, you know, they're putting that on their loved ones. And I think we can encourage them to say, hey, do you really want to burden them with that? Or do you want to
Right.
somebody who does this day in and take care of it more smoothly?
Yeah, I mean, I don't want to get into a sales pitch, but a lot of the benefits of naming either a corporate fiduciary or an attorney or maybe your professional advisor is, you know, it lets the family be family, right? And then it kind of takes that off. Yeah.
What options are modest estates then if they don't have family?
Yeah, well, good question. And that's where a lot of times this middle one, and as I think of Nebraska, right, and I think of maybe the more rural parts of the state, a lot of times it's more common that they'll have their attorney be the one that serves as my PR, especially if it's a smaller estate, right? And because the attorney has the capacity to handle that along with their other workload. So I would say that if you have a smaller estate, not complicated, right? That would be a good suggestion. Hey, your attorney drafted this. They can probably do a good job helping you settle if, and I don't, and there, you can certainly have the kids do a good job. Again, if it's not something very straightforward, it's not complicated, you don't necessarily need to have that professional administration. But, one of the main reasons, I think one of the primary reasons is after the parents pass away, some of those antagonisms, some of that family conflict really bubbles up, right? And it's nice to know, hey, I've got somebody who's a disinterested party that's going to kind of try to be involved with that. All right. Those are good discussion points. Keep them coming. So I think it's important then for us to understand, okay, how are we named? What can we expect, right? So obviously one of the straightforward ones is a specific bequest, right? I leave $10,000 to charity. And so one of the things I would encourage you to do here, especially, if you've been notified, you're in the will, you've been notified, you have a specific bequest, a specific dollar amount is the gift that's coming to our organization. You really don't have to wait till the end to receive your $10,000, right? You could request that distribution prior to closing, and you can be a little more proactive. And in some cases, the personal representative might be happy to, let's get that off my plate. Let's make those gifts. We recently had an estate of our client passed away in January, and one of the first things, she left two $25,000 gifts. And that was one of the first things we did because we had the funds and we wanted to make sure, hey, the charities can use this. But if I was a charity and you have that specific dollar amount and you have an idea, maybe you've gotten a statement now, hey, this is not a problem for the estate. I would encourage you to reach out to that trustee, reach out to that personal representative and say, hey, could we get our distribution? Are you at a point in the administration where we can get, especially if it's a lower amount, and it's not going to really jeopardize the estate administration. That's where that relationship, right? Early on, you're touching base with the attorney, you're touching base with the family, you're touching base with the personal representative, so that's not your first call is, hey, where's our money? But it's actually, oh, this is Michael with charity. Sure, we're able to do that. And again, go back to your flow chart, and let's say that's a probate process we're working under. That inventory, again, is going to tell you, okay, this is a $3 million estate. We're named for $10,000. It shouldn't be an issue for it. Now, there's no law that says they have to give you your money on X date, but I think being proactive in that respect with the specific bequest, I don't see any issue with that.
Have you ever had wonky responses to a request like that?
When I was a plan giving officer, no. And actually, I didn't follow my own advice that I'm giving now. I didn't do that a lot, but no, I haven't. Has anybody ever, that's a good question for the group. Has anybody ever made a request and been told, nope, sorry? Has that been anybody's? Really?
What's coming, but they told me it won't be.
Okay.
So part of me wonders if now hearing this, I can actually go and ask for.
So you're named in the plan, specific dollar amount? You don't have a copy of? Really? Are you like a beneficiary designation, or are you like in a trust or a will as a beneficiary? Or do you have record of anything? Okay. And the donor died when? Over a year? Ooh. So it may be that you're not, yeah, that's a long time. Who's, okay. Yeah, we don't have to, that is a long time. And so maybe that's when we're going to get into maybe some other options for you here in a little bit. Okay. We don't want to get anybody in trouble. So how are we doing? Okay, we're good. We got about a half hour. Other ways, obviously you can be named as a percentage of the estate. I give 10% to charity. This is going to be more problematic for you. And if I was the trustee, I'm going to wait and pay all the bills before I'm giving you the 10%. Why? Because I don't know what 10% is, right? Until everything is settled. So that one you're going to have to just kind of monitor and kind of be patient with that. The residuary beneficiary is right after I do this, after I pay all my bills, the remainder goes to charity X or maybe to the following. This you might have a possibility, depending on where we're at in that process. Let's say, you know, the inheritance tax has been paid, you know, all the bills are paid, you know, you're the only residuary left, right? You're the last payout. You might be able to, prior to closing, just say, hey, is there an ability to get a partial distribution, right? As trustee, a lot of times I do like to give partial distributions out to the family prior to closing, just because, I mean, philosophically, they're the beneficiaries, and it doesn't, if it doesn't hurt. So if you have that residuary, if this is kind of your point, if this is where you're named, you might have the possibility of asking for a partial distribution. And especially if it's something where equal shares, right? Let's say it's equal shares between son, daughter, and charity X, and you're an equal share. There's no issue. It's okay for the trustee. It's okay for the PR to just do an equal distribution, right? They don't have to distribute everything, but they could certainly do an equal distribution if they're at a good spot in the administration. So there's a little more flexibility there. And then the contingent beneficiary, a lot of plans will have that, where, you know, the doomsday clause, right? I lost my mouse here. There it is. You know, if everybody dies in a plane crash, then you're named. And that, you know, you're kind of out of luck there, because the odds of you receiving anything are not great. But it's still, you know, it's still something to perhaps just have on your file. But also, estimating your gift again, right? So why is this important? We're going to get to this here in a little bit, but again, you have those clues in statements, you have clues in the inventory, right? So if you know that you're a 10% beneficiary, a percentage, you know the estate's $1 million. Ooh, boom! I've got a good idea of what we're gonna come close to receiving. Again, that inventory in a probate process is due 3 months after the PR is appointed. And we'll get to why that might be important for you and your organization. Yes?
The inventory is due 3 months. Is there any type of requirements on settling the estate, a timeline, or is that just basically whatever it takes?
So the personal representative needs to continue to update the court on the closing. And I think you're testing me on I don't remember if there's a timeline. They have to continue to give the court reason why it's open. There's no hard line, but if they're not reporting to the court and there's no reason for it to get open, then yeah, then you can have some recourse to kind of petition the court to force somebody to settle that. And somebody jump in there if they know in Nebraska, if there's, I think it's about, yeah, actually, that's a good question, because I got a slide on that right here. No, you're not.
Certain time where keep it open. has to file something. It doesn't automatically.
Right.
Think like, you know, if you're, I don't know what it is, if you're at 18 months, it won't stay open, you have to ask.
Yes, so that's a good point. Thank you for reminding me. So yeah, if it's dragging on past that 18-month part, then if they need to be filing and asking the court for extensions. And obviously, if they're missing deadlines to file inventory, they're missing deadlines to file the inheritance tax return, that's going to cause red flags for the court.
Typically, it's going to be resolved in
I would say, yeah, I would say a year, and I would say normally 6 to 9 months is would be typical, but there's no real hard and fast because every estate is different. But I would say if it's a straightforward estate, you should have things wrapped up between 6 to 9 months or a year, right? Yeah. Yeah.
Hitting required deadlines. But it's kind of complicated to state, and they're selling things, and you're going to really need their cooperation. So when you're 6 months down the road, and you don't have an inventory, and they're selling things, and probably not doing it appropriately, but you really need cooperation. And so you don't want to necessarily go to the court and say, hey, they're blowing these deadlines, need this stuff. I just love to hear your kind of perspective on going down that road with somebody where it's an individual as the fiduciary, but they have an attorney in town who's kind of also not responding and telling them, don't worry, just blow this off.
Yeah, right. So it's an individual. Is it a probate or is it just a trust administration?
This one is, in this case, it is a trust administration.
Okay.
They also, there's some assets, there's enough assets that are entitled to the.
Okay, so there's both. Okay. Individual, attorneys advising them, helping them. And that's really common, is a lot of times, getting back to our who's a PR, I would say 8, 9 times out of 10, when a family member is named, they will have the attorney do the work for them and make all those filings, obviously, because you and I we're not used to that. So we'll hire an attorney. So in that scenario, it's really, and we are going to get to this you have to start to kind of think, okay, what is our gift size? Okay, you're touching on, we need to be sensitive. So you need to be sensitive to this relationship then. And are there family members who maybe are down the road, next generations, that are even more important to your relationship building? Or is this no? This is it? Okay. Yeah. Yes. I think that's where I encourage, if you have, and I think you probably do, you might want to get your own internal folks looking at that and saying, hey, are we at the point where we need to, in a more formal way, file petitions with the court? Do we need to formally send kind of a nice formal letter? Because you can still do that diplomatically, and just to let them know, hey, we were just kind of muddling along, but now we're going to be a little more active and a little more noisy.
Through the attorney, not through the PR.
Okay.
Send a little more letter, and it's kind of a little action, but not enough.
Okay. And that's where you have to, and we'll get to that. You got to do the cost benefit analysis. I think, and I talk to estate planning attorneys, and more, this is a bigger area of their practice, is estate litigation. And if it's a size and you do that and have that internal discussion, it's just a cost benefit analysis, right? Is this worth us having to hire counsel? So I think, it doesn't sound like you're there yet, but I would start to be more noisy, absolutely. And then at some point you have to work your way to that formal litigation. So let's talk just again I know you all know this, but beneficiary designations control dispositions of assets like IRAs, 401ks, life insurance. So just as a point of reminder and just a little refresher, let's take our example. Joe Donor, he's got a 400,000 IRA, the kids are the beneficiary. He's got a $50,000 bank account, kids are the beneficiary. He's got the $200,000 investment account, no beneficiary on that. So there's going to be a probate, or he's named his estate or trust as the beneficiary. If you're named as a beneficiary of the will of the trust, you're not getting any of the IRA, you're not getting any of the bank accounts, you're only up for the 200,000, right? So just something to remember. And that's why it's a great thing, and more, and so many of our topics and our educational topics are 401ks and IRAs, right? Because more and more of our folks, these are their main assets. I keep losing my mouse. I can't point. There it is. These are our main assets for a lot of our donors now, right? And so that's why anything you're doing educationally to remember us in your IRA, remember us in your 401k, because that's going to be the big asset, not the other stuff, right? So just kind of just a little refresher, just to don't forget that main point. So again, with trusts, all of this, again, specific, the same principles, right? Whether you're in the trust for a specific gift, a percentage of the trust, your residuary beneficiary, or you're a contingent, right? So those same principles of, hey, can we have an early distribution, tracking that, that's all the same with trust, even though it might be a little different formally. Again, one advantage of a trust, it could be quicker estate administration, only because there's not that formal process of we have to file with the court our inventory, then we have to file with the court. Everything could be, again, in a perfect world, could be quicker. Again, the disadvantages, no court supervision. You don't have that automatic inventory to kind of fall back on. So statements and reportings, again, if you're in the will, right, you have a right to the statements. You have a right to information. If you have a corporate fiduciary, there's going to be a nice statement for you, and it's going to list the trust value, the expenses. They're all going to be itemized. The distributions, you're going to be able to track those, bills, fees. You should be able to track all of that. And as a beneficiary, you have a right to that reporting and that accounting. Again, if you have an individual, maybe they've hired an attorney to help them, it might not look the same as if a corporate fiduciary were to do it. But again, it's important to know that you have a right as a beneficiary, again, to have a good idea of what values are, statements, and those type of things. And you can request those things. So here, we kind of touched on this. So how long should it take? Again, it depends. It really does depend. Every estate is different. All your donors are different. All their assets are different. There is not, in 9 years of working as a trust officer, none of them have been the same. And so it really does depend on the type of assets they own. But again, typically, I think you can expect, if it's pretty straightforward, we have bank accounts, we don't have any real estate, maybe our donor was living in a retirement facility, there's not a house to sell, there aren't cars to sell, I don't have a limited life. If it's pretty straightforward, you should be able to wrap things up in 6 to 9 months or a year, okay? So I would say, if you're asking me, Michael, how long is this going to take? It should be done within a year, but everything is different. We have as many variety as there are of people. That's kind of the variety we have. I have, unfortunately, I'm currently working on an estate and trust that we're coming on 2 years on our administration. And that's the case where we have this third bullet point down here. Things that take time with estate administration, it's a disputed estate, right? And so unfortunately, that's going to delay things. Other things that are going to delay things, real estate, right? Let's say they've got a junky piece of swampland in Florida, and that's the main property, we're in trouble, right? That's going to take a long time. Business interests, right? Is it a complicated LLC? Are there business interests internationally? So again, the more complicated the estate, the longer the time. If you have these things, you're going to look more in a year or more, okay? But again, a nice thing is in Nebraska, the bad thing is we have inheritance tax. The good thing is it does give a marker for those trustees and those personal representatives. They have to get that paid 1 year from the date of death of your donor. So the nice thing is once that's paid, that's usually a good marker for you that, okay, that's the last hurdle, unless you've got these bugaboos down here. And more we're seeing this. I think, we've had kind of a breakdown in our family, units the last 20 years. There's a lot more family conflict. There's a lot more potential for disputes. And so that's really kind of causing delays and in my case, my example I gave you, that's exactly what's happening. And it's been 2 years. So here's kind of touching on, Keith, kind of what you're hitting at. Do we need an attorney? At what point do you need to ask yourself, okay, do we need to have some help here because this thing's not moving along? So things to look out for. Let's say, again, let's back up to day one. All right, we know we're in Jane Donor's will and trust estate. We know it's a big one. Okay, that's usually the first case on, do you need an attorney? Size is important on the estate, right? But if you know from the very day one, ooh, this was a family that did not get along, they hate each other, right? You can kind of anticipate, well, let's kind of see how things are going here. You need to have maybe a little forward thinking. If you anticipate these things, you might consider, depending on the size of your share of the estate, getting an attorney involved. Ambiguous language, right? What if they name your organization and you don't know what the heck they're talking about, right? And so maybe it could be, if it's sizable enough and if there's conflict, you might need an attorney to guide you through that process so that you carry out the terms of the will or of the trust. Or what about, do we still do that? Will we still do that, right? Is that program even still in existence? Or is that something that they've named that they want you to do that, listen, we're not going to do that as an organization, right? And so those might be cases where, okay, we need to ask the court. I don't know if you've heard the doctrine of Cypre, right? So the donor's intent, maybe they've named a program that no longer exists in your organization, right? So you might need to go, and let's say they're naming you $1 million, so it's substantial. You can't just take it and do something else. You kind of need the court's blessing. You might need to get an attorney and have them sign off on, okay, this program doesn't exist anymore, but Judge, will you allow us to do it for this program, right? And so I'm sure, especially this, has anybody had that? Has anybody been named recently where, wow, that doesn't exist anymore, or we can't do that? Has anybody ever had that experience recently? Could be. Yep. No examples that you don't have to, Keith, you've had one? Yeah. What, and you don't have to dive into the details, but. Okay. Great.
As state law changes, and some things just change relative to education funding this fall.
Uh-huh.
And so the question becomes, can we change some? We can change ourselves under HIPAA, as codified,
Okay.
but some we have to take to county court to say, this is something we can't do anymore. Here's our proposed alternative. Can you, and ask them to sign off. And generally, I think everything we've taken recently has got through without a problem.
That's great.
You never know.
That's great. We had one where when I worked for the Diocese of Lincoln, I think there were 3 charities and the total dollar amount was about 45,000, if I'm remembering right. And we did decide, yeah, we had an attorney who was the PR, and they kind of messed up, and they were messing up. And it was looking like our charities were not going to get their gift. We did hire an attorney, and we did eventually get the full amount that those 3 charities were supposed to get. And so it doesn't have to be millions and millions of dollars, right? And here's the point I want to maybe make something to think about, that last bullet point, advisory committee, right? Do you have a group of your supporters, your donors, who are estate planning attorneys, right? Are their advisors CPAs, someone that can guide you in this process? Because you shouldn't be expected to have the expertise in this area of estate litigation, right? Your job is to get the support for your organization. So if you don't have an advisory committee that maybe is helping you, that might be something to think about, is that maybe this is a group that could actually look at the language in your documents, maybe. And so they could give you that feedback and say, hey, Michael, I think we're at the point where you need to kind of jump in and in a more formal way be involved in this process. So does anybody have professional advisory committees that serve you and kind of review your documents for you? Okay, good. Something to maybe think about. Donors, or it could just be friends in the community, right? You might reach out to an estate planning attorney and say, hey, would you be willing to sit on our advisory committee to kind of help us, guide us in this area? And then stewarding your gift, right? Obviously very important, really important up top here, internal communication, right? And it's hard in the area of planned giving to show progress, isn't it? I mean, and I remember when I worked for the Diocese of Lincoln, I had an annual report that I gave where it showed our progress. And I tried my hardest with my, the folks I reported to say, hey, we had these new expectancies. We think they're going to be at this dollar amount. So internal communication is huge. And then let's take the example of the gift comes in, right? You want to do a nice job of showing your board, your teams, hey, look, we received a $500,000 bequest. This is important. This is why our planned giving program is so important. However, you got to be sensitive to these things, right? Donor sensitivity. Is the gift anonymous? Then you can't be doing those types of activities. I had one example when I worked at the diocese. We had a donor pass away. She had no children, and she made a sizable gift. And we did publicize it, and we got a little bit of anger from nieces and nephews, right? And so that was kind of, we stubbed our toe on that. So you do need to be sensitive to family, and be sure before we're doing a public recognition, is everybody okay with that, right? So the last thing you want to do is do what I did. You publicize, hey, we got this great gift. And then I had 3 nieces and nephews that were really angry with me because, I didn't do an effective job of giving them a heads up on that. But, stories tell, right? Does that happen, Courtney? Yeah.
They still don't want you to publish the gift, but that was like the donor's intent. Like they don't want it to be anonymous. It wasn't anonymous. And it's good for us to share that story. But in our instance, it was like a brother and nieces and nephews who thought they should have gotten the money.
Oh, yeah.
Instead of just us.
Yeah.
And they were upset. But we were like, we're sorry you're upset, but like, this isn't an anonymous gift. It's a sizable gift. And we want to share and inspire our other donors to do the same type of things.
I think the first thing you said was they wanted us to share it. If that's clear, yeah, I think that's what you have to fall back on. And just, again, that's where you do your cost benefit analysis, right? Usually the people that are upset, they're just cranky people who are stingy, and they're never going to give you. Right.
that was kind of how we tried to play both sides.
That's a great way to do it. You can maybe compromise with the family, right? And say, okay, we appreciate that. Can we do things a little more general? Anything you can do in your building that relationship while your donor's alive, and Keith mentioned that fund agreement, if you can get in writing, hey, Michael Henkenius, I'm going to leave the University of Nebraska $1 million. I want you to, have that in your fund agreement if you can get those. And then you have that bulletproof armor that you show family and say, look, this was their desire. We have to honor that, right? That's the best case scenario, but obviously we all are dealing, most of the time we're in the gray area, right? And so you just have to kind of weigh that. But stories, right? If anything you can do in your materials, in your conversations, hey, can I tell you what so-and-so did for us? That's just awesome gold for you. And then ongoing family stewardship, right? Make sure you're telling the family, hey, look, mom and dad's gift is, this is the scholarship recipient this year, and anything you can do ongoing with the surviving family, they could be your next generation of donors, right? So I think that's it. We're going to wrap up here. Again, key takeaways, it's important to know if you're in the plan. Don't be shy during the process. You have rights as a beneficiary. Maintain the relationships after you're notified, right? If we take a step back on our donors still alive, they've told us we're in their will. Work hard to maintain that relationship. Let's say they're still alive. Let's say they told you when they're 60, hey, you know what? You're in our will. Annually, at least, tell them thank you. Ask them, have you updated your documents? And then obviously the importance of legacy societies. All those things take time. All those things take effort. But I hope that was helpful for you. It looks like, are we done? We're pretty much done. I'm happy to stay and visit afterwards, though, if anybody wants to visit a little bit more. So thank you for your time and attention.
So we're starting our summer break now. No meeting in July or August, but we'll be back in September and October. I think September is Legacy Societies, done by Christine from our group, and then October will be, I think we have the wrong one out there, but I think it's really going to be the how women are driving plan, getting focused on that, particularly from a marketing perspective with Margaret Holman from New York. Thank you, Michael.
Thank you, everybody. Thank you. I hope that was helpful.
They have
Well, you
a
guys did.
question for you about one of